First issue, whether Azlan, Faizal and Nadira are liable for breaching their duty as the trustees of the trust deed, even though Azlan is frequently absent in conducting the trust, and Faizal, who is already retired from being a trustee when Nadira gained the unauthorized benefits for herself. Let's moving on to the first law, breach and liability. Trustee will be liable once they breach their duty, and it's a concept where the liability will be imposed on trustee or trustees for failing to carry out his duties properly or exceed his power and failing to execute their duties imposed in the trust deed. In Regal, Hastring and Gulliver, the breach of trust happened the moment the trustee gained the unauthorized benefits for himself as a result of his position. Meanwhile, in Prof. Dr. Siti Nurmala binti Sheikh Obid and two others and Lembaga Pemegang Amanah College Islam Malaysia, where the trustee were found liable for breach of trust when their actions directly caused loss to the trust. According to Target Holdings and Redfern, the House of Lords underscored the principle that a beneficiary is entitled to have the trust administered in a strict accordance with the provisions of the trust instrument or even in the general law. The duty of a trustee is not merely to avoid causing loss, but also to ensure that every act is authorized and aligned with the trust purpose. Furthermore, in Royal Brunei Airlines and Tong Kok Ming Philip, the trustee may be held liable even if they act in good faith, unless they are excused by an exemption clause in the trust instrument or relief by the court. Additionally, trustee liability is strictly personal, where they only be held liable personally for their own breaches, since it is not a vicarious liability, even if it was done by a co-trustee. However, in Breeze and Stroke, it highlights that the trustee generally have a duty to act jointly in administrating the trust. Due to that, they may also be liable for failing to prevent another trustee breach, especially when there is collusion or concurrence on the part of the trustee. A sleeping or non-active trustee may still be held liable. This is affirmed in Ri Haji Ali, Hafsa and Muhammad Zain unless the court finds that they act honestly and reasonably. Moreover, Section 35 of the Trustee Act further clarifies that a trustee is only liable for money or asset they actually receive, misconduct or mishelp, unless their loss resulted from their own willful default. Therefore, when there is no willful misconduct, the trustee will not be held entitled for the acts or omission of co-trustee or other third parties. Next, the trustee also have a duty upon their appointment to exercise and familiarize themselves with the trust term and related document. If they discover any irregularities or breaches by past trustees, they must investigate and act, or otherwise, failure to do so may result in them being liable for that breach. This can be referred to res terhern, where the new trustee is not liable for breaches that occurred before the appointment, but failing to investigate and take an action would make him liable for the breach as well. Likewise, in Head and Gulp, a retiring trustee will not be held liable if the breach happens after his retirement, unless it can be proved that the retirement was due to conceal a breach. If a trustee steps down knowing that a remaining or incoming trustee will act in breach of trust, then the retirement may be seen as concealing wrongdoing. In addition, if a trustee is also a beneficiary, it was highlighted in Chillingworth and Chambers that their beneficial share in the trust may be used to compensate for the loss caused by the breach. Trustee liability for breaches is joint and several, meaning that each trustee can be sued individually or altogether, and the claimant can recover the full amount from any one of them unless they can show that they were not complicit or negligent, as in Bahin and Hughes. On the other hand, as stated in Nestle and National Westminster Bank, if the breach did not result in any actual loss, no compensation can be claimed. If an authorized investment performs better than an unauthorized one, the trustee will not be liable for loss, but if it performs worse, the trustee may be asked to cover the difference or reinvest appropriately, depending on the beneficiary's decision.
First and foremost, it is important to analyze whether each trustee, which is Nadira, Azlan and Faizal, have breached their duties, and if so, whether they are liable. First and foremost, the focus will be on Nadira's role and conduct in administering the trust. As derived from the facts presented, Nadira committed a clear breach of trust, as in January 2025, she had transferred 300,000 ringgit from the trust account into her own personal account. Her actions were not limited to a one-off occurrence, but instead reflect a pattern of repeated breaches provided by the three separate instances. This is supported by the facts given, which reveals that in the second incident, Nadira withdrew 60,000 ringgit from the trust account to finance renovations to her home kitchen. Furthermore, she utilized 100,000 ringgit to purchase shares registered in her own name. In addition to this, Nadira expended 50,000 ringgit of trust funds in a luxury vacations in Europe with her family, transferred 30,000 ringgit to her daughter for private university tuitions, and donated 60,000 ringgit to a local NGO for a flood relief project. In the third incident, Nadira further withdrew 150,000 ringgit directly from the trust account to purchase a new car, which was subsequently registered under her own name. It is evidence that Nadira's conduct constitutes a serious breach of her duty as a trustee. This can be said as that because Nadira's repeated action by misappropriating the trust account for her own personal purposes clearly constitute unauthorized self-dealing and falls clearly within the scope of breach as defined in the case of Regal, Hastings and Gulliver. Nadira's action also resulted in financial depletions of the trust account, affirming that she breached the trust, as in the case of Prof. Dr. Siti Nurmala binti Sheikh Obid and two others, and Lembaga Pemegang Amanah College Islam Malaysia. As in the case of Target Holdings and Redfern, the beneficiaries, which are Aliyah, Faris and Zara are entitled to have the trust account administered by Alia, but instead she chose to act dishonestly and irresponsible. Nadira's deviation from the standard by treating the trust account as a personal fund amounts to a bad mismanagement. Relying on the principle from the case of Raya Brunei Airlines and Tan Kok Ming Philip, Nadira's deliberate and self-serving conduct rendered her fully accountable for the losses sustained by the trust, especially since the trust instrument did not provide any exemption clause to excuse any liability for the misconduct. Although the trustee's liability, which is Nadira's liability, is strictly personal, however, by relying to the principle in the case of Breeze and Stroke, since the testator, which is Puan Kamaria, also appointed Azlan and Faizal as a trustee for the said trust, the two of them have a duty to act jointly in administering the trust, meaning that Azlan and Faizal may also be held jointly liable for failing to prevent Nadira's breach and fail to administer the trust. In light of Section 35, it is clearly states that liability is supposedly on individual itself, but if the breach caused by Nadira's is also due to Azlan and Faizal's own willful default, they might not escape liability of being sued together for the breach happened. We shall now focus on analysing the conduct of Azlan in administering the trust and determine whether or not he shall be liable for the breach of trust. Upon examination of the facts, it is clearly shown that Azlan, despite being a named trustee, was frequently absent and took no active role in managing the trust. Instead, he informally permitted Nadira to take full control in managing the trust. This brought evidence that Azlan is a sleepy or non-active trustee or so-called passive trustee, since he failed to carry out his duty in administering the trust and left everything in the hand of Nadira without proper oversight. In applying the principle in the case of Breeze and Stork, Azlan as a trustee are required to act jointly with his other co-trustee in administering the trust account, and his failure to monitor or intervene where his co-trustee, which is Nadira, misapplying the trust property may result in a joint liability. This can be further affirmed by applying the principle in the case of Haji Ali, Hafsa and Muhammad Zain, with such a passive trustee, which is in this case Azlan, who only stand by and do nothing when the trust account was being misused by Nadira, will not be relieved liability by the court and will also be held liable together with Nadira, since they have a duty to equally administer the trust account. In relation to Faizal, his liability as a former trustee must be assessed in light of his resignation from the trust in June 2024. Generally, Faizal as a retired trustee may not be held liable for breach of the trust that occurred after his retirement. However, the law may still hold the retired trustee, which is Faizal, to be liable if his retirement is to facilitate a breach, especially when during his time in office, he had contemplated that a breach will occur and he retired to avoid his involvement in it. Upon true assessment of the factual circumstances, it clearly states that Faizal, before his resignation, became aware of Nadira's intention to use the trust fund for her own personal purpose, but decided to step down rather to raise objection. Based on this line, it is evident that Faizal has foresaw and reasonably foreseen that Nadira will eventually misuse the trust account for her own personal benefit, but failed to act to stop her from carrying her intention, and he also failed to inform or even report to the beneficiaries about the intention of Nadira to misuse the trust account, but rather he retired before the commission of breach took place to avoid himself from being jointly liable with Nadira. Faizal's failure to act will render him liable for the breach occurred even after he retired. This can be further affirmed as stated in the principle from the case of Head and Gold, in which Faizal, though he was already retired, can still be held liable since his retirement was to consider breach as he neglecting in administering the trust and failed to act to prevent the breach from occurring. Instead, he chose to step down. In conclusion, Nadira, Azlan and Faizal can be held liable for breaching their duty as trustee of the trust deed. As stated in the case of Bahin and Hughes, Alia, as a beneficiary of the trust deed, can choose to either sue Azlan, Faizal and Nadira individually or all together, and Alia can recover the full amount from any of them. Relying also in the principle from the case of Nestle and National Westminster Bank PLC, since the breach resulted in actual loss of money, Alia can claim for compensations and the two of them may be asked to recover the differences or invest appropriately depending on Alia's decision.
Okay, for the second issue, the issue is whether Nadira, Azlan and Faizal can raise any legal defences for the breach of trust. Okay, moving on to the law, a trustee may be excused from liability if they acted reasonably and honestly, and if the court finds it is fair to excuse them. However, this is not an automatic, which requires the trustee must prove all three limbs. As cited in the case Mardens and Regan, the court explained the section 63, which acting honestly means with good intention and no personal gain, reasonably means using the care of sensible business person, and fairly excused depends on whether it is fair. Based on all the facts, this form the basis for how courts decide if a trustee should be excused. In another case is the case of Rike. The court stressed that relief from breach of trust is possible if the trustee acted with full honesty and care. But this relief is rare and only applies in exceptional cases where breach is minor or technical. Okay, let's see the next cases, which is Malaysian cases, Ong Sukyo and Ong Sukri, which the court confirmed that Section 63 is applied at the court's discretion and depends heavily on defects. It also made clear there is no fixed rule and each case must be decided based on its circumstances. This case is an important Malaysian authority showing that courts apply Section 63 in a fair and flexible way. And the next case is Haji Ali bin Muhammad Noor. The court held that even trustee not directly involved in a breach can be still liable if they fail to act or supervise properly. To be excused under Section 63, all three elements must be strictly proven. Okay, let's delve into a different example, which the case of Kor Pai Kien and another and Chiu Sien Look. This case provided a different example of acceptable conduct in which the court found no breach when trust property was stolen from a car during a short stop. The trustee had taken the same care for the personal item. This shows that if a trustee acts reasonably, the Section 63 may apply. Okay, looking at the nature of the trustee in the case of Bartlett and Barclays Bank Trust Co. Limited, in the context of nature of the trustee, this case illustrated that a professional trustee failed to monitor a company where trust money was invested. The court held that professional trustee must meet a higher standard and cannot delegate key responsibilities. Failing to supervise can be still a breach, even without directly misusing funds. Looking at Section 64, which this section protects a trustee from personal liability if the breach was done with the written consent of a fully informed beneficiary who is full age and sound of mind. The court may then use the beneficiary's interest to cover the loss. As cited in the case of Ramasamy anak lelaki Kamachi and Tayalan, the court recognized the application of Section 64 to impound the shares of beneficiaries who gave consent. However, it is also held that the consent must be informed and in writing. Only those who participate or consented could be made to indemnify the trustee. However, the court in Re Somerset held that the court will not exercise its discretion under the Section 64 unless the beneficiary knew and understood all the relevant facts which subsequently amounted to breach of trust. In another case, Fletcher and Collis, the court held that if a beneficiary was involved in the trustee's breach, they cannot later sue the trustee for that breach. However, this does not affect the rights of other beneficiaries, as one beneficiary's consent does not bind the others. And lastly, in the case of Stafford and Stafford, the court held that if a beneficiary accepts or acquiesces to a breach after it happens, they may be barred from suing the trustee for it. Their conduct can serve as protection for the trustee.
So, moving on to the application, Azlan, Faizal and Nadira may attempt to raise this defense to protect themselves from liability for breach of trust. They may obtain full or partial relief if the court is satisfied that they have fulfilled all the requirements under Section 63, namely, they acted honestly, acted reasonably and ought fairly to be excused. The burden of proof rests on Azlan, Faizal and Nadira to establish all the three things. As clarified by the court in Marsden and Reagan regarding of each limb of Section 63, Nadira's act of transferring 300,000 ringgit from the trust account into her personal account, withdrawing 60,000 ringgit to renovate her kitchen, buying 100,000 ringgit worth of shares in her own name, spending 50,000 ringgit on a luxury vacation in Europe with her family, transferring 30,000 ringgit to pay her daughter private university costs, and withdrawing 150,000 ringgit to buy herself a new car are seen as not honest, as she acted with selfish motives and did not genuinely seek to benefit the trust. She also failed to act reasonably, since a prudent and reasonable trustee would never use trust fund for personal purpose, but would safeguard them for the beneficiary's interest. Additionally, Nadira is unlikely to satisfy the limb of ought fairly to be excused to escape liability. Given her deliberate and selfish misuse of the trust fund for her own benefit, it would not be equitable for the court to relieve her from the liability. With reference to the case of Rike, the court is unlikely to relieve Nadira from liability. Her breach were not minor or procedural in nature, but involved deliberate, large-scale misappropriation of the trust fund for personal use such as home renovation, luxury travel, her daughter's education expense, and purchase of a car. This action showed clear dishonesty and lack of prudence. As Rike emphasized that relief is only for rare, minor breach committed with complete honesty and care, Nadira's action go beyond that standard and constitute a major breach. Therefore, she is unlikely to be excused from the liability. Moving on to the case of Ong Soo Kyok and others and Ong Soo Kui, which affirmed the application of Section 63 in Malaysia is subject to the court's discretion and depends heavily on the specific facts of the case. In assessing whether Nadira should be excused from liability of breach of her duty as a trustee, the court will consider all the circumstances of her conduct. Since her action involved intentional and repeated misuse of trust fund for personal benefit, it is unlikely to the court would exercise its discretion to relieve her from the liability. Okay, as we can see from this current scenario, Azlan still can be held liable despite not being directly involved in the misappropriation of trust fund by Nadira. Azlan, as a trustee, had a duty to actively monitor the trust administration. His failure to supervise Nadira's action and allowing her to manage the trust without proper oversight may be seen as imprudent. The court, in the case of Sri Haji Ali bin Haji Muhammad Noor, emphasized that to succeed under Section 63, Azlan need to satisfy all the three requirements. Firstly, there is no evidence that Azlan had acted dishonestly in managing the trust fund, as he did not properly benefit from the misappropriated funds or acted with any fraudulent motives or selfish motive. His decision to let Nadira handle the trust appears to have been based on convenience, as he is a businessman who frequently travels overseas and is rarely involved in the administration of trust rather than on any dishonest motive. Therefore, he may be able to satisfy the honesty requirement. However, Azlan is unlikely to satisfy the reasonableness limit. As a trustee, he had a duty to actively monitor and supervise the trust administration. By allowing Nadira to take full control without proper oversight, especially knowing he was often absent overseas, he failed to exercise the standard of care expected from a reasonable trustee. A reasonable trustee would have checked on Nadira's management, sought regular updates, and ensured that the trust fund were used appropriately. Lastly, for the third limb, the court will consider whether it is equitable to excuse Azlan given all the circumstances. Although Azlan did not personally benefit from the misuse of the trust fund, his failure to check Nadira's management allowed serious breach to occur. Therefore, it is unlikely for the court to find it fair to relieve him from the liability. So, in Faizal's scenario, he may also be liable because he fails on the second limb under Section 63, particularly on the requirement to act reasonably. Faizal can still be liable even without direct involvement in the breach, as he failed to act prudently. Faizal was aware of Nadira's intention to use the trust fund for her personal purpose before he resigned, but choose to step down instead of raising objections or taking steps to prevent the breach. A reasonable trustee in his position would have advised Nadira against such misappropriation and acted prudently to protect the trust property. Therefore, Faizal is also unlikely to succeed in raising the defence under Section 63. Moving on, applying to the case of Ko Pai Yen and another and Chiu Sien Look, the court will consider whether Azlan managed the trust with the same care he would have used for his own affairs. In Ko Pai Yen, the trustee was excused because the law occurred. In applying the case of Bartlett and Barclays Bank Trust Co Limited to Azlan's case, he owed a duty of care to actively supervise the trust. By allowing Nadira to take complete control without oversight, especially given his frequent absence, he failed to discharge his duty. Even though he did not misuse the fund himself, his failure to monitor her action would likely be seen as a breach of trust under principle in Bartlett, making it unlikely he could satisfy the reasonableness limit under Section 63. Okay, let's continue. In regard to Section 64, there is no evidence that Alia ever consented, either orally or in writing. While Faris and Zara were aware of Nadira's action and chose to remain silent, there is no indication they gave written consent or fully understood the details and consequence of the breach, as also be recognized in Ramasamy, Anak Lelaki Kamachi and Tayalan. Furthermore, following Ri Somerset, the court would not exercise its discretion to protect Nadira and Azlan unless it is shown that any of Alia, Faris and Zara had full knowledge of the facts amounting to the breach. Given these circumstances, it is unlikely that Azlan and Faizal could rely on Section 64 to avoid liability. Next, by applying the case of Fletcher and Collis, Faris and Zara may be barred from bringing an action against the trustee if it can be shown that they actively participated in or consented the breach. However, the facts only indicate that they were aware of Nadira's action but chose to stay silent to avoid conflict. There is no evidence that they were involved in planning or carrying out the breach itself. Therefore, they did not participate in the sense required to bar them from claiming. Even if they would bar individually, Fletcher and Collis confirmed that their consent would not bind Alia, who did not know of the breach until later and retains the right to sue. So, for the last part, regarding to Stafford and Stafford, while Faris and Zara's silence might be seen as acquiescence to Nadira's conduct after the breach, which could bar them from later challenging it, Alia cannot be said to have acquiescence, as she only discovered the misappropriation in January 2025. Her lack of knowledge means she did not show any acceptance or approval of the breach. Therefore, Adia's rights to pursue action against trustee remain unaffected. In conclusion, Nadira, Azlan and Faizal have failed to raise the legal defence for breach of trust under Section 63 and Section 64 of the Trustee Act.
Lastly, we will be discussing the issue of whether Alia would be able to recover the trust property or its value from Nadira. A possible remedy would be an equitable remedy of tracing. Tracing means the right to follow trust property. Where trust property has gone amiss as a result of a breach of trust, the beneficiary has a remedy. This is a remedy to trace the trust property, provided the judge holds that the assets are traceable in equity. Tracing allows the beneficiary to follow trust property when it has been wrongfully disposed or converted. The purpose is to reclaim the original asset or any property representing it. To obtain this equitable remedy, the beneficiary must satisfy 3 established conditions, which is, firstly, there must be an initial fiduciary relationship. Secondly, the trust property must still be in a traceable form. And thirdly, the tracing of property must not lead to an equitable result. As for the first requirement that need to be fulfilled, which is that there must be an initial fiduciary relationship, it must be demonstrated that such a relationship exists, whether it arises from an express trust or a constructive trust. The question of tracing does not arise in the absence of a constituted trust, as per stated in the case of Re-Halid Estate. Tracing is available as a remedy only after a trust has been established. As stated in the case of Re-Block, any later relationship between the beneficiary and the person holding the trust property does not have to be fiduciary, provided that the original fiduciary relationship between the trustee and beneficiary has been established. All fiduciary relationships have either a property interest or a legal interest in the property. As established in the case of Sinclair and Brugam, if the trustee passes the trust property to a third party, the beneficiary can still trace and claim it from that person without having to show that any fiduciary relationship exists between them. The requirement that needs to be fulfilled is the trust property must still be in a traceable form. In the case of Re-Block, it has been held that the equitable remedy of tracing is only available to a beneficiary if there is identifiable property to trace, meaning the trust property must still exist in some form. The property remains traceable even if it has been changed or converted into a different form. However, if the property has been used up or completely dissipated, it can no longer be traced. If trust funds have been used to acquire property, it is necessary to consider whether the purchase was made of a mixed or unmixed fund. As stated in the case of Re-Halid Estate, if it is from mixed fund, in which where the trustee has combined the trust fund with personal fund, the beneficiary is not able to reclaim the property itself, since it was not acquired exclusively using trust money. Accordingly, in these circumstances, the beneficiary will only be entitled to claim a charge over the property acquired with the mixed fund, limited to the value of the trust money used in the purchase, provided that the property remains identifiable and traceable. Moreover, if the purchase of a property using a trust fund was made of an unmixed fund, the beneficiary is entitled to choose either to claim ownership of the property acquired with the trust fund or to impose a change over the property equivalent to the amount of trust money that was used. In an unmixed fund, if the claim cannot be traced against a bona fide purchaser for value without notice, but the claim can be traced against an innocent volunteer while he retains the property. However, an innocent volunteer is not a constructive trustee and does not have the additional liabilities of a constructive trustee. To determine the traceability of the property, there are a few situations that can be referred to. Firstly, if trust money has been transferred to a third party, the property can still be traced as long as the recipient accepted in a good faith and did not provide any value in return, which is the third party is an innocent volunteer. However, if the trust money has been spent on services such as paying for meals, accommodations, or similar expenses, it is generally regarded as untraceable. Second situation that can be looked at if the trust money or property or the proceeds from from it have been applied to pay off a specific debt, that property is considered untraceable. And thirdly, if trust money is used to acquire a tangible asset such as car or a house, that property remains traceable as long as it is still exist. However, if the funds are used to purchase something intangible like shares, the property is regarded as untraceable. When trust money has been used to buy property that later generates a profit, two distinct scenarios arise, which is firstly, if the trustee made a purchase and any profit derived from the property must be returned to the trust, regardless of whether the funds were mixed or kept separate. This is because a trustee has a fiduciary duty not to use trust property for personal benefit. However, secondly, if an innocent third party, which is an innocent volunteer, use money from an unmixed fund to acquire the property, that person is entitled to retain any profit earned. This is justified by the fact that the third party does not owe any fiduciary duty to the beneficiary and acted in a good faith. Lastly, the third requirement that needs to be fulfilled is tracing of property must not lead to an equitable result. If allowing the beneficiary to trace the property would result in an unfair outcome, the court may decline to grant this equitable remedy. For example, where a third party who acted in a good faith, which is an innocent volunteer, has used trust money to purchase property for themselves, it would generally be inequitable to allow tracing against them. As explained in Redeep Law, if an innocent volunteer bought a land with trust fund and registered the title in their own name, the court would consider it unfair to require them to sell the land. However, if the same fund were given to the volunteer to acquire the land to be held in the trustee name, it would be fair for the beneficiary to trace and claim the property. In this scenario, the most appropriate remedy available to Alia as a beneficiary is the equitable remedy of tracing. For Alia to succeed this remedy, there are three requirements that need to be satisfied, which is firstly, there must be an initial fiduciary relationship. In this scenario, a fiduciary relationship clearly exists between Alia and the trustee, as they were both formally appointed by Puan Kamara in a form of express trust. This satisfies the requirements stated in Real Estate, which confirm that tracing is only available once a trust has been constituted. The second requirement that needs to be satisfied is that the trust property must still be in a traceable form. The remedy is applicable if there is identifiable property to trace and exist in the same form. In this scenario, some of the fund can be identified as traceable and untraceable. Firstly, the share that Nadira purchased using 100,000 of the mixed trust funds are intangible property, which would ordinarily be considered as untraceable. However, because these shares have appreciated in value to 135,000 and the proceeds remain identifiable, they can still be traced and claimed by the beneficiary. Nadira made the purchase of the share using the trust money, and any profit derived from the purchase shall be returned back to the trust, but the beneficiary would only be entitled to claim a charge over the property acquired with the mixed fund, limited to the value of the trust money used in the purchase, provided that the property remains identifiable and traceable. Secondly, Nadira has also purchased a new car registered under her own name using the unmixed trust fund, amount to 150,000. The car are considered as a tangible asset, and the property remains traceable as long as the car that she has bought still exists. The beneficiary Alia may be able to choose either to claim ownership of the car or to impose a charge over the car equivalent to the amount of trust money that has been used. In contrast, the RM50,000 spent on a luxury vacation and the RM60,000 donated to the NGO have been dissipated are likely untraceable, as money used for service is generally deemed untraceable. The RM30,000 transferred to the daughter may still be traced if the funds remain identifiable and the daughter is treated as an innocent volunteer. Lastly, the third requirement that needs to be satisfied is tracing of property must not lead to an inequitable title, as explained in Redeep Law. If the property has been transferred to an innocent volunteer who used it in a Lastly, the third requirement that needs to be satisfied is tracing of property must not lead to an inequitable title, as explained in Redeep Law. If the property has been transferred to an innocent volunteer who used it in a good faith to acquire property for themselves, the court may decline to enforce tracing if it would be unfair. However, Nadira is not an innocent volunteer. She was a trustee misappropriating fund in breach of duty. Therefore, it will be equitable to trace and recover the property or its value from her. In conclusion, Alia should be entitled to trace and recover the shares and the car acquired using the trust fund. The sum dissipated on the vacation and charitable donation are likely untraceable. Nadira, as a trustee who acted in breach of trust, cannot rely on any defense of good faith, and the court is likely to uphold Alia's claim to the asset or their value. Thank you. That's all.